Ladies and gentlemen, welcome back to jury service. Yesterday we left off where both sides rested and closed the presentment of their evidence. So today, as I explained to you, we're going to read the jury charge to you, and then we're going to proceed with the closing arguments. Thank you for your patience this morning. I know we're very late in getting started. It took us all this time to finalize the charge I have to read to you. The charge is very lengthy. It is 52 pages. The part I have to read to you is 42 pages. We will get through it. Don't worry. You don't have to take notes because you are going to take this jury charge back to the jury room with you. I have to read it out loud to you because the law requires me to do it. It is the only way that we can guarantee that everyone has had it read to them. Again, you get to take this to the back. You will have an opportunity to review it back there. In continuing to discharge your responsibilities as jurors, you will continue to observe all of the instructions I have given you up until this point, plus these written instructions. Do not disregard the written instructions. It could constitute juror misconduct. Please listen carefully as I begin the reading of the instructions. The charge of the court in cause number 2020 CR 2721 reads as follows. Members of the jury, the defendant, Jilson Avelar-Rodriguez, aka Andres Rodriguez, stands charged in counts 1, 2, and 3 of the indictment with the offense of capital murder alleged to have been committed on or about the 30th day of September 2018 in Bexar County, Texas. The defendant has pleaded not guilty. Our law provides that a person commits the offense of murder if he intentionally or knowingly causes the death of an individual or intends to cause serious bodily injury and commits an act clearly dangerous to human life that causes the death of an individual, or commits or attempts to commit a felony other than manslaughter, and in the course of and in furtherance of the commission or attempt, or in immediate flight from the commission or attempt, he commits or attempts to commit an act clearly dangerous to human life that causes the death of an individual. Our law provides that a person commits the offense of capital murder if he intentionally or knowingly causes the death of more than one individual during the same criminal transaction, or if he intentionally causes the death of an individual in the course of committing or attempting to commit the offense of burglary. Our law provides that a person commits the offense of manslaughter if he recklessly causes the death of an individual. The offenses of burglary and aggravated assault with a deadly weapon are felony offenses. Our law provides that a person commits the offense of burglary if, without the effective consent of the owner, the person enters a habitation with intent to commit a felony, theft, or an assault, or enters a habitation and commits or attempts to commit a felony, theft, or an assault. Our law provides that a person commits the offense of assault if the person intentionally, knowingly, or recklessly causes bodily injury to another, or if the person intentionally or knowingly threatens another with imminent bodily injury. A person commits the offense of aggravated assault with a deadly weapon if the person commits an assault as defined above and uses or exhibits a deadly weapon during the commission of the assault. A person commits the offense of theft if he unlawfully appropriates property with intent to deprive the owner of the property. Individual means a human being who is alive. Deadly weapon means a firearm or anything manifestly designed, made, or adapted for the purpose of inflicting death or serious bodily injury, or anything that in the manner of its use or intended use is capable of causing death or serious bodily injury. Firearm means any device designed, made, or adapted to expel a projectile through a barrel by using the energy generated by an explosion or burning substance or any device readily convertible to that use. Bodily injury means physical pain, illness, or any impairment of physical condition. Serious bodily injury means bodily injury that creates a substantial risk of death or that causes death. Serious permanent disfigurement or protracted loss or impairment of the function of any bodily member or organ. Attempt to commit an offense occurs if, with specific intent to commit an offense, a person does an act amounting to more than mere preparation that tends but fails to affect the commission of the offense intended. Effective consent means assent in fact, whether expressed or apparent, and includes consent by a person legally authorized to act for the owner. Owner means a person who has title to the property, possession of the property, whether lawful or not, or a greater right to possession of the property than the defendant. By the term enter, as used above, is meant to intrude any part of the body or any physical object connected with the body into the habitation. A habitation means a structure that is adapted for the overnight accommodation of persons and includes each separately secured or occupied portion of the structure and each structure appurtenant to or connected with the structure. Appropriation and appropriate mean to acquire or otherwise exercise control over property other than real property. Appropriation of property is unlawful if it is without the owner's effective consent, or if the property is stolen and the actor appropriates the property knowing it was stolen by another. Property means tangible or intangible personal property or documents, including money, that represents or embodies anything of value. Deprive means to withhold property from the owner permanently or for so extended a period of time that a major portion of the value or enjoyment of the property is lost to the owner. A person acts intentionally or with intent with respect to the result of his conduct when it is his conscious objective or desire to cause the result. A person acts intentionally or with intent with respect to the nature of his conduct when it is his conscious objective or desire to engage in the conduct. A person acts knowingly or with knowledge with respect to a result of his conduct when he is aware that his conduct is reasonably certain to cause the result. A person acts knowingly or with knowledge with respect to the nature of his conduct or to circumstances surrounding his conduct when he is aware of the nature of his conduct or that the circumstances exist. A person acts recklessly or is reckless with respect to the result of his conduct when he is aware of but consciously disregards a substantial and unjustifiable risk that the result will occur. A person acts recklessly or is reckless with respect to the circumstances surrounding his conduct when he is aware of but consciously disregards a substantial and unjustifiable risk that the circumstances exist. The risk must be of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the actor's standpoint. The law of duress, paragraph 5. It is an affirmative defense to prosecution that this actor engaged in the prescribed conduct because he was compelled to do so by threat of imminent death or serious bodily injury to himself or another. Such compulsion as applied in this case exists only if the force or threat of force would render a person of reasonable firmness incapable of resisting the pressure. The defense of duress is unavailable if the actor intentionally, knowingly, or recklessly placed himself in a situation in which it was probable that he would be subjected to compulsion. The burden of proof of the affirmative defense of duress rests upon the defendant. And to establish such defense, the defendant must prove the affirmative defense of duress by a preponderance of the evidence. The term preponderance of the evidence means the greater weight and degree of the credible evidence in this case. Now, keeping in mind these instructions regarding the affirmative defense of duress, upon consideration of each offense charged against defendant as instructed herein, if you find from the evidence beyond a reasonable doubt that the defendant, Jilson Avelar-Rodriguez, aka Andres Rodriguez, did commit such offense as instructed in this charge, but you further find as to that offense that the defendant has proved by a preponderance of the evidence each of the following elements of duress. Jilson Avelar-Rodriguez, aka Andres Rodriguez, was compelled to engage in the conduct by a threat of an imminent death or serious bodily injury to himself, and the threat would render a person of reasonable firmness incapable of resisting the pressure. And Jilson Avelar-Rodriguez, aka Andres Rodriguez, did not intentionally, knowingly, or recklessly place himself in a situation in which it was probable that he would be subject to compulsion. Then you will find in favor of the defendant, Jilson Avelar-Rodriguez, aka Andres Rodriguez, on his affirmative defense of duress, and find that he acted under duress. However, if upon consideration of each offense being charged against defendant as instructed herein, you find from the evidence beyond a reasonable doubt that the defendant, Jilson Avelar-Rodriguez, aka Andres Rodriguez, did commit such offense as instructed in this charge, and you do not find that Jilson Avelar-Rodriguez, aka Andres Rodriguez, has proved by a preponderance of the evidence each of the elements of the defense of duress as listed above, that you will find against the defendant, Jilson Avelar-Rodriguez, aka Andres Rodriguez, on the affirmative defense of duress, and find that he did not prove that he acted under duress. Paragraph 6, the law on self-defense. You are instructed that it is a defense to this prosecution if the conduct of the defendant was justified by law. A person is justified in using force against another when and to the degree the person reasonably believes the force is immediately necessary to protect himself against the other's use or attempted use of unlawful force. A person is justified in using deadly force against another if the person would be justified in using force against the other in the first place, as set out above, and when and to the degree the person reasonably believes the deadly force is immediately necessary to protect himself against the other's use or attempted use of unlawful deadly force. The use of deadly force against another is not justified in response to verbal provocation alone. Reasonable belief means a belief that would be held by an ordinary and prudent person in the same circumstances as the defendant. Deadly force means force that is intended or known by the person using it to cause, or in the manner of its use or intended use, is capable of causing death or serious bodily injury. The defendant is not required to prove self-defense. The state must prove beyond a reasonable doubt that the defendant did not act in self-defense. A person who has a right to be present at the location where the deadly force is used, and who has not provoked the person against whom the deadly force is used, and who is not engaged in criminal activity at the time of the deadly force is used, is not required to retreat before using deadly force. If all three of these factors are met, then in determining whether such actor reasonably believed that the use of deadly force is necessary, a finder of fact may not consider whether the actor failed to retreat. You are instructed that a person's belief that deadly force was immediately necessary is presumed to be reasonable if that actor knew or had reason to believe that the person against whom deadly force was used unlawfully and with force entered or was attempting to enter unlawfully and with force the actor's occupied habitation, and the actor did not provoke the person against whom the force was used, and that actor was not otherwise engaged in criminal activity. You are instructed that the facts giving rise to this presumption of reasonableness must be proven beyond a reasonable doubt. If such facts are proven beyond a reasonable doubt, you may find that the element of the offense sought to be presumed exists, but you are not bound to so find, and even though you may find the existence of such element, the state must prove beyond a reasonable doubt each of the other elements of the offense that is charged against the defendant. If the jury has a reasonable doubt as to the existence of a fact or facts giving rise to the presumption fails, and the jury shall not consider the presumption for any purpose. Keeping in mind these instructions regarding self-defense, upon consideration of the offense that charged against defendant as instructed herein, if you find from the evidence beyond a reasonable doubt that the defendant, Jilson Avelar-Rodriguez, aka Andres Rodriguez, did commit such offense as instructed in this charge, if instructed to do so, you must decide whether the state has proven beyond a reasonable doubt that the defendant, Jilson Avelar-Rodriguez, aka Andres Rodriguez, did not act in self-defense. Therefore, upon consideration of the offense that is charged against defendant as instructed herein, if you find from the evidence beyond a reasonable doubt that the defendant, Jilson Avelar-Rodriguez, aka Andres Rodriguez, did commit such offense as instructed herein, but you further find from the evidence that, or you have a reasonable doubt as to whether, at the time he did so, Jilson Avelar-Rodriguez, aka Andres Rodriguez, reasonably believed that Nicholas Milanovich was using or attempting to use unlawful deadly force against Jilson Avelar-Rodriguez, aka Andres Rodriguez, and Jilson Avelar-Rodriguez, aka Andres Rodriguez, reasonably believed that his use of deadly force and the degree of deadly force used were immediately necessary to protect himself against Nicholas Milanovich's use or attempted use of unlawful deadly force, and Jilson Avelar-Rodriguez's, aka Andres Rodriguez's, use of deadly force was not in response to verbal provocation alone, then you will find in favor of the defendant on the law of self-defense as to Nicholas Milanovich, finding that the defendant did act in self-defense. However, upon consideration of the offense that is charged against defendant as instructed herein, if you find from the evidence beyond a reasonable doubt that the defendant, Jilson Avelar-Rodriguez, aka Andres Rodriguez, did commit such offense as instructed herein, and you find from the evidence beyond a reasonable doubt that Jilson Avelar-Rodriguez, aka Andres Rodriguez, did not reasonably believe that Nicholas Milanovich was using or attempting to use unlawful deadly force against Jilson Avelar-Rodriguez, aka Andres Rodriguez, or Jilson Avelar-Rodriguez, aka Andres Rodriguez, did not reasonably believe that the use of deadly force and degree of deadly force used was immediately necessary to protect himself against Nicholas Milanovich's use or attempted use of unlawful deadly force, or Jilson Avelar-Rodriguez's, aka Andres Rodriguez's, use of deadly force was in response to verbal provocation alone, then you will find against the defendant on his justification defense of self-defense as to Nicholas Milanovich, and find that the defendant did not act in self-defense when shooting Nicholas Milanovich. Count 1, capital murder, more than one individual during the same criminal transaction. Now, if you unanimously find from the evidence beyond a reasonable doubt that on or about the 30th day of September 2018 in Bexar County, Texas, the defendant, Jilson Avelar-Rodriguez, aka Andres Rodriguez, did intentionally or knowingly cause the death of an individual, namely Nicholas Milanovich, by shooting Nicholas Milanovich with a deadly weapon, namely a firearm, and on or about the 30th day of September 2018, Jilson Avelar-Rodriguez, aka Andres Rodriguez, did intentionally or knowingly cause the death of another individual, namely Julia Wright, by shooting Julia Wright with a deadly weapon, namely a firearm, and both murders were committed during the same criminal transaction. But you also find from a preponderance of the evidence that the defendant was acting under duress, as instructed in paragraph 5 at that time, then you will find the defendant, Jilson Avelar-Rodriguez, aka Andres Rodriguez, not guilty of the offense of capital murder as charged in count 1 of the indictment, and do not consider paragraph 8 or 9, but proceed to paragraph 10. Or, if you unanimously find from the evidence beyond a reasonable doubt that on or about the 30th day of September 2018 in Bexar County, Texas, the defendant, Jilson Avelar-Rodriguez, aka Andres Rodriguez, did intentionally or knowingly cause the death of an individual, namely Nicholas Milanovich, by shooting Nicholas Milanovich with a deadly weapon, namely a firearm, and on or about the 30th day of September 2018, Jilson Avelar-Rodriguez, aka Andres Rodriguez, did intentionally or knowingly cause the death of another individual, namely Julia Wright, by shooting Julia Wright with a deadly weapon, namely a firearm, and both murders were committed during the same criminal transaction. And you do not find by a preponderance of the evidence that the defendant was acting under duress at that time, but you find that the defendant acted in self-defense as instructed in paragraph 6 when shooting Nicholas Milanovich with a deadly weapon, namely a firearm, then you will acquit the defendant of the offense of capital murder as charged in count 1 of the indictment, say by your verdict not guilty of the charged offense of capital murder in count 1, and next consider paragraph 8 to decide whether the defendant is guilty of a lesser included offense in count 1. Or, If you unanimously find from the evidence beyond a reasonable doubt that on or about the 30th day of September 2018 in Bexar County, Texas, the defendant, Jilson Avelar-Rodriguez, aka Andres Rodriguez, did intentionally or knowingly cause the death of an individual, namely Nicholas Milanovich, by shooting Nicholas Milanovich with a deadly weapon, namely a firearm, and on or about the 30th day of September 2018, Jilson Avelar-Rodriguez, aka Andres Rodriguez, did intentionally or knowingly cause the death of another individual, namely Julia Wright, by shooting Julia Wright with a deadly weapon, namely a firearm. And both murders were committed during the same criminal transaction, and you do not find by a preponderance of the evidence that the defendant was acting under duress at that time, and you do not find a reasonable doubt, and you find beyond a reasonable doubt that the defendant was not acting in self-defense at that time, then you will find the defendant, Jilson Avelar-Rodriguez, aka Andres Rodriguez, guilty of the offense of capital murder as alleged in count 1 of the indictment, and do not consider paragraphs 8 or 9, but proceed to paragraph 10. Or if you do not find beyond a reasonable doubt, or you have a reasonable doubt as to whether on or about the 30th day of September 2018 in Bexar County, Texas, the defendant, Jilson Avelar-Rodriguez, aka Andres Rodriguez, did intentionally or knowingly cause the death of an individual, namely Nicholas Milanovich, by shooting Nicholas Milanovich with a deadly weapon, namely a firearm. And on or about the 30th day of September 2018, Jilson Avelar-Rodriguez, aka Andres Rodriguez, did intentionally or knowingly cause the death of another individual, namely Julia Wright, by shooting Julia Wright with a deadly weapon, namely a firearm, and both murders were committed during the same criminal transaction, then you will acquit the defendant of the offense of capital murder as charged in count 1 of the indictment, say by a verdict not guilty of the charged offense of capital murder in count 1. Do not consider paragraph 8, but next consider paragraph 9 to decide whether the defendant is guilty of the lesser included offense of murder in count 1. Count 1, lesser included offenses, Julia Wright. Having found that the defendant did not act under duress and having found that the defendant acted in self-defense when shooting Nicholas Milanovich, you will now consider the following lesser included offense. If you unanimously find from the evidence beyond a reasonable doubt that on or about the 30th day of September 2018 in Bexar County, Texas, the defendant, Jilson Avelar-Rodriguez, aka Andres Rodriguez, did intentionally or knowingly cause the death of an individual, namely Julia Wright, by shooting Julia Wright with a deadly weapon, namely a firearm, or did intend to cause serious bodily injury and committed an act clearly dangerous to human life that caused the death of an individual, namely Julia Wright, by shooting Julia Wright with a deadly weapon, namely a firearm, or did commit or attempt to commit a felony other than manslaughter, namely burglary, and in the course of and in furtherance of the commission or attempt or in immediate flight from the commission or attempt, the defendant committed or attempted to commit an act clearly dangerous to human life that caused the death of an individual, namely Julia Wright, by shooting Julia Wright with a deadly weapon, namely a firearm. Then you will find the defendant, Jilson Avelar-Rodriguez, aka Andres Rodriguez, guilty of the lesser included offense of murder in count 1. If you do not find beyond a reasonable doubt, or if you have a reasonable doubt thereof, then you will acquit the defendant of the lesser included offense of murder in count 1, say by a verdict not guilty of the lesser included offense of murder in count 1, and next consider whether the defendant is guilty of the lesser included offense of manslaughter in count 1. If you unanimously find from the evidence beyond a reasonable doubt that on or about the 30th day of September 2018, in Bexar County, Texas, the defendant, Jilson Avelar-Rodriguez, aka Andres Rodriguez, did recklessly cause the death of an individual, namely Julia Wright, by shooting Julia Wright with a deadly weapon, namely a firearm, then you will find the defendant, Jilson Avelar-Rodriguez, aka Andres Rodriguez, guilty of the lesser included offense of manslaughter in count 1, do not consider paragraph 9, but proceed to paragraph 10. If you do not find beyond a reasonable doubt or have a reasonable doubt thereof, then you will find the defendant not guilty of the lesser included offense of manslaughter in count 1. Do not consider paragraph 9, but proceed to paragraph 10. Paragraph 9, count 1, lesser included offense of murder. If you unanimously find from the evidence beyond a reasonable doubt that on or about the 30th day of September 2018, in Bexar County, Texas, the defendant Jilson Avelar-Rodriguez, aka Andres Rodriguez, did intend to cause serious bodily injury and committed an act clearly dangerous to human life that caused the death of an individual, namely Nicholas Milanovich, by shooting Nicholas Milanovich with a deadly weapon, namely a firearm, or did commit or attempt to commit a felony other than manslaughter, namely burglary, and in the course of and in furtherance of the commission or attempt or in immediate flight from the commission or attempt, the defendant committed or attempted to commit an act clearly dangerous to human life that caused the death of an individual, namely Nicholas Milanovich, by shooting Nicholas Milanovich with a deadly weapon, namely a firearm. And you do not find by a preponderance of the evidence that the defendant was acting under duress as instructed in paragraph 5 at that time, and you find beyond a reasonable doubt that the defendant was not acting in self-defense, then you will find the defendant Jilson Avelar-Rodriguez, aka Andres Rodriguez, guilty of the lesser included offense of murder in count 1 and proceed to paragraph 10. If you do not so unanimously find the above as to Nicholas Milanovich, or you have a reasonable doubt thereof, or you find that the defendant was acting in self-defense as to Nicholas Milanovich, or you find that he was acting under duress as to Nicholas Milanovich, you will next consider the following lesser included offense. If you unanimously find from the evidence beyond a reasonable doubt that on or about the 30th day of September 2018 in Bexar County, Texas, the defendant, Jilson Avelar-Rodriguez, aka Andres Rodriguez, did intend to cause serious bodily injury and committed an act clearly dangerous to human life that caused the death of an individual, namely Julia Wright, by shooting Julia Wright with a deadly weapon, namely a firearm, or did commit or attempt to commit a felony other than manslaughter, namely burglary, and in the course of and in furtherance of the commission or attempt or in immediate flight from the commission or attempt, the defendant committed or attempted to commit an act clearly dangerous to human life that caused the death of an individual, namely Julia Wright, by shooting Julia Wright with a deadly weapon, namely a firearm, and you do not find by a preponderance of the evidence that the defendant was acting under duress, as instructed in paragraph 5 at that time, then you will find the defendant, Jilson Avelar-Rodriguez, aka Andres Rodriguez, guilty of the lesser included offense of murder in count 1 and proceed to paragraph 10. If you do not find beyond a reasonable doubt or have a reasonable doubt thereof, or you find that he was acting under duress as to Julia Wright, then you will find the defendant not guilty of the lesser included offense of murder in count 1. Paragraph 10, we're moving on to count 2, capital murder of Nicholas Milanovich. Now, if you would unanimously find from the evidence beyond a reasonable doubt that on or about the 30th day of September 2018 in Bexar County, Texas, the defendant, Jilson Avelar-Rodriguez, aka Andres Rodriguez, did intentionally cause the death of an individual, namely Nicholas Milanovich, by shooting Nicholas Milanovich with a deadly weapon, namely a firearm. And Jilson Avelar-Rodriguez, aka Andres Rodriguez, was in the course of committing or attempting to commit the offense of burglary of a habitation. But you also find from a preponderance of the evidence that the defendant was acting under duress, as instructed in paragraph 5 at that time. Then you will find the defendant, Jilson Avelar-Rodriguez, aka Andres Rodriguez, not guilty of the offense of capital murder as charged in count 2 of the indictment, and do not consider paragraphs 11 or 12, but proceed to paragraph 13. Or, if you unanimously find from the evidence beyond a reasonable doubt that Jilson Avelar-Rodriguez, aka Andres Rodriguez, did intentionally cause the death of an individual, namely Nicholas Milanovich, by shooting Nicholas Milanovich with a deadly weapon, namely a firearm, and Jilson Avelar-Rodriguez, aka Andres Rodriguez, was in the course of committing or attempting to commit the offense of burglary of a habitation, and you do not find by a preponderance of the evidence that the defendant was acting under duress at that time, but you find that the defendant acted in self-defense as instructed in paragraph 6 when shooting Nicholas Milanovich with a deadly weapon, namely a firearm. Then you will acquit the defendant of the offense of capital murder as charged in count 2 of the indictment. Say by your verdict not guilty of the charged offense of capital murder in count 2, and next consider paragraph 11 to decide whether the defendant is guilty of the lesser included offense of burglary in count 2. Or, if you unanimously find from the evidence beyond a reasonable doubt that Jilson Avelar-Rodriguez, aka Andres Rodriguez, did intentionally cause the death of an individual, namely Nicholas Milanovich, by shooting Nicholas Milanovich with a deadly weapon, namely a firearm, and Jilson Avelar-Rodriguez, aka Andres Rodriguez, was in the course of committing or attempting to commit the offense of burglary of a habitation, and you do not find by a preponderance of the evidence that the defendant was acting under duress at that time, and you find beyond a reasonable doubt that the defendant was not acting in self-defense at that time, then you will find the defendant, Jilson Avelar-Rodriguez, aka Andres Rodriguez, guilty of the offense of capital murder as alleged in count 2 of the indictment, and do not consider paragraphs 11 or 12, but proceed to paragraph 13. Or, if you do not find beyond a reasonable doubt, or if you have a reasonable doubt as to whether Jilson Avelar-Rodriguez, aka Andres Rodriguez, did intentionally cause the death of an individual, namely Nicholas Milanovich, by shooting Nicholas Milanovich with a deadly weapon, namely a firearm, and Jilson Avelar-Rodriguez, aka Andres Rodriguez, was in the course of committing or attempting to commit the offense of burglary of a habitation, then you will acquit the defendant of the offense of capital murder as charged in count 2 of the indictment. Say by your verdict not guilty of the charged offense of capital murder in count 2. Do not consider paragraph 11, but proceed to paragraph 12 to decide whether the defendant is guilty of the lesser included offense of murder in count 2. Paragraph 11, count 2, lesser included offense of burglary. Now, if you unanimously find from the evidence beyond a reasonable doubt that on or about the 30th day of September 2018 in Bexar County, Texas, the defendant, Jilson Avelar-Rodriguez, aka Andres Rodriguez, did intentionally or knowingly enter a habitation with intent to commit the felony offense of aggravated assault with a deadly weapon, or theft, or an assault without the effective consent of Nicholas Milanovich and or Julia Wright, the owners, then you will find the defendant, Jilson Avelar-Rodriguez, aka Andres Rodriguez, guilty of the lesser included offense of burglary in count 2, and proceed to paragraph 13. If you do not so find beyond a reasonable doubt, or if you have a reasonable doubt thereof, you will find the defendant not guilty of the lesser included offense of burglary in count 2, and proceed to paragraph 13. Paragraph 12, count 2, lesser included offense of murder. If you unanimously find from the evidence beyond a reasonable doubt that on or about the 30th day of September 2018 in Bexar County, Texas, the defendant, Jilson Avelar-Rodriguez, aka Andres Rodriguez, did intend to cause serious bodily injury and committed an act clearly dangerous to human life that caused the death of an individual, namely Nicholas Milanovich, by shooting Nicholas Milanovich with a deadly weapon, namely a firearm, or did commit or attempt to commit a felony other than manslaughter, namely burglary, and in the course of and in furtherance of the commission or attempt or in immediate flight from the commission or attempt, the defendant committed or attempted to commit an act clearly dangerous to human life that caused the death of an individual, namely Nicholas Milanovich, by shooting Nicholas Milanovich with a deadly weapon, namely a firearm. And you do not find by a preponderance of the evidence that the defendant was acting under duress as instructed in paragraph 5 at that time, and you find beyond reasonable doubt that the defendant was not acting in self-defense, then you will find the defendant Jilson Avelar-Rodriguez, aka Andres Rodriguez, guilty of the lesser included offense of murder in count 2 and proceed to paragraph 13. If you do not find beyond a reasonable doubt or have a reasonable doubt thereof, then you will find the defendant not guilty of the lesser included offense of murder in count 2 and proceed to paragraph 13. Count 3. Paragraph 13, count 3, capital murder of Julia Wright. Now, if you unanimously find from the evidence beyond a reasonable doubt that on or about the 30th day of September 2018, in Bexar County, Texas, the defendant Jilson Avelar-Rodriguez, aka Andres Rodriguez, did intentionally cause the death of an individual, namely Julia Wright, by shooting Julia Wright with a deadly weapon, namely a firearm, and Jilson Avelar-Rodriguez, aka Andres Rodriguez, was in the course of committing or attempting to commit the offense of burglary of a habitation. But you also find from a preponderance of the evidence that the defendant was acting under duress as instructed in paragraph 5 at that time. Then you will find the defendant Jilson Avelar-Rodriguez, aka Andres Rodriguez, not guilty of the offense of capital murder as charged in count 3 of the indictment, and do not consider paragraph 14. But if you do not so find, or if you have a reasonable doubt thereof, you will acquit the defendant of the offense of capital murder as charged in count 3 of the indictment, say by your verdict not guilty of the charged offense of capital murder in count 3, and next consider paragraph 14 to decide whether the defendant is guilty of a lesser included offense. Count 3, lesser included offenses. This is paragraph 14. If you unanimously find from the evidence beyond a reasonable doubt that on or about the 30th day of September 2018 in Bexar County, Texas, the defendant Jilson Avelar-Rodriguez, aka Andres Rodriguez, did intend to cause serious bodily injury and committed an act clearly dangerous to human life that caused the death of an individual, namely Julia Wright, by shooting Julia Wright with a deadly weapon, namely a firearm, or did commit or attempt to commit a felony other than manslaughter, namely burglary, and in the course of and in furtherance of the commission or attempt or in immediate flight from the commission or attempt, the defendant committed or attempted to commit an act clearly dangerous to human life that caused the death of an individual, namely Julia Wright, by shooting Julia Wright with a deadly weapon, namely a firearm. And you do not find by a preponderance of the evidence that the defendant was acting under duress, as instructed in paragraph 5 at that time, then you will find the defendant Jilson Avelar-Rodriguez, aka Andres Rodriguez, guilty of the lesser included offense of murder in count 3 and proceed to paragraph 15. If you do not find beyond a reasonable doubt or have a reasonable doubt thereof, then you will find the defendant not guilty of the lesser included offense of murder in count 3, but next consider the different lesser included offense of manslaughter in count 3. If you unanimously find from the evidence beyond a reasonable doubt that on or about the 30th day of September 2018, in Bexar County, Texas, the defendant Jilson Avelar-Rodriguez, aka Andres Rodriguez, did recklessly cause the death of an individual, namely Julia Wright, by shooting Julia Wright with a deadly weapon, namely a firearm, and you do not find by a preponderance of the evidence that the defendant was acting under duress, as instructed in paragraph 5 at that time, then you will find the defendant Jilson Avelar-Rodriguez, aka Andres Rodriguez, guilty of the lesser included offense of manslaughter in count 3 and proceed to paragraph 15. If you do not find beyond a reasonable doubt or have a reasonable doubt thereof, then you will find the defendant not guilty of the lesser included offense of manslaughter in count 3, but next consider the different lesser included offense of burglary in count 3. If you unanimously find from the evidence beyond a reasonable doubt that on or about the 30th day of September 2018, in Bexar County, Texas, the defendant Jilson Avelar-Rodriguez, aka Andres Rodriguez, did intentionally or knowingly enter a habitation with intent to commit the felony offense of aggravated assault with a deadly weapon or theft or an assault without the effective consent of Nicholas Milanovich and or Julia Wright, the owners, then you will find the defendant Jilson Avelar-Rodriguez, aka Andres Rodriguez, guilty of the lesser included offense of burglary in count 3. If you do not so find beyond a reasonable doubt, or if you have a reasonable doubt thereof, You will find the defendant not guilty of the lesser included offense of burglary in count 3 and proceed to paragraph 15. Paragraph 15, our law provides a defendant may testify in his own behalf if he elects to do so. This, however, is a right accorded to a defendant, and in the event he elects not to testify, that fact cannot be taken as a circumstance against him. In this case, the defendant has elected not to testify, and you are instructed that you cannot and must not refer or allude to the fact throughout your deliberations or take it into consideration for any purpose whatsoever as a circumstance against him. You are instructed that you must not communicate with or provide any information to anyone or receive any information from anyone by any means about this case. You may not use any electronic device or media such as telephone, cell phone, smartphone, iPhone, BlackBerry, iPad, tablet, or computer, the internet, any internet service, or any text or instant messaging service, or any social media platform, internet chat room, blog, or website, to include but not limited to Facebook, MySpace, Instagram, Snapchat, LinkedIn, YouTube, TikTok, Twitter, or X, to communicate with anyone any information or receive any information from anyone about this case, or to conduct any research about this case until I accept your verdict. Written statements made by a witness to investigators or other officers or police reports made by officers and tendered by the prosecution to the defense for purpose of cross-examination are not part of the evidence unless introduced in evidence. Many times, statements and reports may be marked with an exhibit number but are neither offered nor received in evidence. The court can send only statements and reports received in evidence to the jury room. The grand jury indictment is not evidence of guilt. It is the means whereby a defendant is brought to trial in a felony prosecution. It is not evidence, nor can it be considered by you in determining whether the defendant is guilty or not guilty. During your deliberations in this case, you must not consider, discuss, nor relate any matters not in evidence before you. You should not consider nor mention any personal knowledge or information you may have about any fact or person connected with this case which is not shown by the evidence. The burden of proof in all criminal cases rests upon the state throughout the trial and never shifts to the defendant. All persons are presumed to be innocent, and no person may be convicted of an offense unless each element of the offense is proved beyond a reasonable doubt. The fact that a person has been arrested, confined, or indicted for, or otherwise charged with the offense gives rise to no inference of guilt at his trial. The law does not require a defendant to prove his innocence or produce any evidence at all. The presumption of innocence alone is sufficient to acquit the defendant unless the jurors are satisfied beyond a reasonable doubt of the defendant's guilt after careful and impartial consideration of all the evidence in this case. The prosecution has the burden of proving the defendant guilty, and it must do so by proving each and every element of the offense charged beyond a reasonable doubt. And if it fails to do so, you must acquit the defendant. It is not required that the prosecution prove guilt beyond all possible doubt. It is required that the prosecution's proof excludes all reasonable doubt concerning the defendant's guilt. In the event you have a reasonable doubt as to the defendant's guilt after considering all the evidence before you and these instructions, you will acquit him and say by your verdict not guilty. You are instructed that you are not to let bias, prejudice, or sympathy play any part in your deliberations. You are the exclusive judges of the facts proved, of the credibility of the witnesses, and of the weight to be given the testimony. But the law of the case you must receive from the court as contained in these instructions and be governed thereby. You must disregard any comment or statement made by the court during the trial or in these instructions which may seem to indicate an opinion with respect to any fact, item of evidence, or verdict to be reached in this case. No such indication was intended. After argument of counsel, you will retire to the jury room, select your own presiding juror, and proceed with your deliberations. After you have reached a unanimous verdict, the presiding juror will certify thereto by filling in the appropriate forms attached to this charge and signing his or her name as presiding juror. The forms are not intended to suggest to you what your verdict should be. Your sole duty at this time is to determine whether the defendant is guilty or not guilty under the indictment in this cause, and restrict your deliberations to the issue of whether the defendant is guilty or not guilty and nothing else. If the jury wishes to communicate with the court, they shall notify the bailiff. Any and all communication relative to the case must be written, prepared by the presiding juror, and submitted to the court through the bailiff. Respectfully submitted, Judge Maria J. Mesa of the 226th District Court of Bexar County, Texas. I will sign the jury charge, hand it to my bailiff. State, you may proceed with your closing argument.
May it please the court. Members of the jury, that was a substantial jury charge. One of the bigger I've seen, and I am a visual learner, so I'd like to talk to you a little bit about that jury charge, and to do so, I have prepared a flowchart, which I hope will be helpful. So, I'm showing the jury what I've marked for record purposes only, as states 116. All right, so, the first count, as charged in our indictment, is capital murder of multiple persons. This defendant is guilty of capital murder of multiple persons if in the same criminal episode he killed more than one individual in a way that was not excused by the law, okay? And that's what we've been talking about this entire trial. It's the evidence we've been bringing. So, if he's guilty of capital murder, you find him guilty on count one, and you wouldn't consider the lesser includeds under count one. But, if you didn't, if you were to find this defendant guilty of killing Julia, but not guilty of killing Nicholas, either because you don't think he did it, or because you think it was excused, then you would find him guilty of the murder of Julia, okay? All right. If you found him guilty of killing Nicholas, but you did not find that he killed Julia, then you would find him guilty of the murder of Nicholas Milanovich, okay? So, capital murder of multiple persons. If you find him guilty of both murders, it's capital murder as charged in count one. If you find the murder of either of those two individuals, then it would be murder of either of those two individuals, right? Beyond that, if you were to find that the defendant did not kill Nicholas, did not murder Nicholas for whatever reason, and he did kill Julia, but he didn't have the intent to kill Julia, then you would find him guilty of manslaughter of Julia, okay? And that's all contained within count one. So after, and again, if you found him guilty of count one as charged, you would not consider these lesser includeds. Either way, we'd move on to count two. Count two is the capital murder of Nicholas Milanovich. And to find that true, you would find that in the course of a burglary, the defendant intentionally murdered Nicholas, which we believe is what the evidence has shown. However, if you found that the defendant was not guilty of burglary, but that he did murder Nicholas, then you would find him guilty of murder unless you believe that he acted in self-defense, which we talked about in Board 9. We talked about the law of self-defense as it applies to home invasion scenarios and how it's not available in those type of scenarios. So I don't believe that he acted in self-defense. I don't believe that self-defense was available to him in the course of a burglary. But it's in the charge I'm going to talk about. So, if you found him guilty of murder here as a lesser included on count one, you would also find him guilty of murder, or as, let's start over. If you found him guilty of murder as a lesser included of count two, you would also find him guilty of murder as a lesser included of count one, right? Okay. If you found that the defendant did not intentionally murder Nicholas, but that he committed the burglary, then you would find him guilty of burglary. Okay? And that's count two. And once again, just like count one, we found him guilty of the count as charged in the indictment. You don't have to consider those lesser includeds. Just the count as charged in the indictment. Count three, charged capital murder, that in the course of that same burglary, the defendant intentionally murdered Julia Wright. Find that to be true beyond a reasonable doubt, you'll find him guilty of count three. If you do not, we would move on to the same process as we used in count two, with one little complication. What that process is, if you found the defendant had not committed the burglary, but did commit the murder, you would find him guilty of murder. And again, if you found him guilty of murder here in count three of Julia, you would find him guilty of murder of Julia in count one, because it's the same charge. However, if you found that he did not intend to kill Julia, but that he did kill Julia, you would find him guilty of manslaughter, which once again mirrors that lesser included in count one. If you found that the defendant did not murder Julia, but did commit the burglary, you would find him guilty of burglary. Here's the one additional factor. If you found that the defendant intended to commit the burglary, and in the course of that burglary, Julia was killed, then the defendant would be guilty of the murder of Julia. So he would be guilty of the murder of Julia, and the instructions make it clear, have made it clear. He's guilty of the murder of Julia, whether he intended to kill her, or whether he killed her during a burglary that he intended. If he intentionally killed her during a burglary that he intended, then he's guilty of capital murder, as charged in count three. I hope that all makes sense. I'm going to leave it up. And the one other thing is, if you believe the duress claim the defendant has been making this whole time, it'll cover everything. It'll all be gone. But I don't think the evidence will support it. I want to thank you for your patience on Tuesday. Tuesday we called 9 or 10 witnesses. We spent a lot of time talking about the crime scene. We gave you a lot of pieces of evidence, but not a lot of answers. We did that so you would see those answers as the investigation went on with Detective Duke. So I thank you for your patience, and I thank you for your attention while that was all being built up. And I think now, here at the end of the week, we have a really clear idea of what happened in this case. What happened is this. This defendant, back in September of 2018, was living with his girlfriend, Valerie, in the Sonoma Canyon apartments up there by the medical district. While he was living there, he noticed some degree of foot traffic coming in and out of another apartment. He may have had other information, we don't know, that those people were involved in the use and potential sale of narcotics. And this has been on my mind this whole trial. We've been talking a lot about Nicholas and Julia's apartment and the marijuana that was found there, almost a pound of marijuana. And there's two reasons why we brought that evidence to you. One is it's true. The second reason is because I think it provides the clearest motive we have for why this defendant committed this burglary and the murders that happened with it. He saw people that he thought were dealing drugs, so he figured he could go in there, he could bust in, he might find money, he might find product, and most importantly, he thought no one would care. And I think that provides important context for this crime. But it's important to keep in mind that we're talking about almost a pound of marijuana in the context of a capital murder. It's important that it was there, but it does absolutely nothing to diminish its guilt, and it does absolutely nothing to suggest that Nicholas and Julia somehow deserve this. That's absurd. So I just wanted to make that absolutely clear. That's why that evidence was in front of you. Well, this defendant, he decided to burglarize them. He found his mask, he got his gloves, he got his tire iron. He went and he carefully gained entry to the apartment through that downstairs window. He did it quietly so they wouldn't wake up. He did it, I believe Detective Duke described it as a skillful job of breaking and entering. He stepped onto that love seat on the way in. We don't know how much time he spent looking for things downstairs. But we know at some point he went upstairs. And when he was upstairs, he saw Nicholas and Julia lying in bed. He chambered around in his 9mm, forgetting that he already had a round chambered, which is where that loaded Browning round came from. And he shot twice, one for each of them. Shot them both in the head. He took Nicholas's gun. He took Julia's lockbox. And he got out of there. Up until this point, the defendant had remarkably good luck, I think. He didn't leave behind DNA that could be used. He didn't leave behind fingerprints that could be used. You heard about all the testing that went on to try and find those things. But he was wearing gloves. He was wearing a mask. He was careful. But what he couldn't have counted on was the fact that Julia woke up. The medical examiner described her making it outside as impressive, and I think that's an understatement. She was hemorrhaging blood from her jugular that had been severed by that bullet. She had a hole from her cheek to just behind her ear from a bullet, and she made it all the way outside to try to get help. And because she did that, the police got there that morning. They didn't come days later. They got there that morning because of the strength she showed. And I think that's incredible. And it's good luck because it allowed this investigation to get started. But that wasn't enough. After the defendant left the apartment, he went to Melissa's. He went to Melissa's, he took off the mask, the hoodie, the gloves that you're going to have in evidence and you're going to have a chance to take a look at to compare them to that finger that was found right by the window. You'll have that to make that comparison yourselves. And Detective Duke said anyone could do it. So I'd encourage you to. He went to Melissa's and he took a shower or whatever, but at some point, as Valerie testified, she woke up and he wasn't there. So she called him. So he had to leave Melissa's. So he left his stuff there. He left the lockbox there. At some point, he had to ask Melissa what that pill bottle was, because you know that he went into that apartment looking for product. So he hoped he found some. Turns out it was just methadone because Julia was trying to recover from her addiction. So that was all he found. He left it there. He went back to his apartment, and Melissa did the right thing. She tried to do it as quietly as she could. She tried to do it anonymously. She didn't want to be involved in any of this, and she told you as much from the stand. She didn't want to be here. But she did the right thing. She contacted an attorney who turned it over to the police, and that's where they got the name Jilson Avelar-Rodriguez, this defendant. Well, you heard about all the work that Duke did in this case. You heard that Valerie allowed a search of her apartment at Duke's request, probably believing that he wouldn't find anything, but he found that lockbox. That lockbox, whose code corresponds to the paperwork that Julia had from her methadone treatment, 617. And you saw the detective put that in and open the lockbox right up. Eventually, the evidence was strong enough that Duke could interview the defendant. During that interview, the defendant told a lot of lies. He told a lot of different lies that didn't match up with each other. But he also confessed. And in that confession, you don't have to take him at his word. You don't have to believe everything he said. You know that he said things that only the murderer would know. He knows how he got into the apartment. He knew where the victims were when they were shot. He knew where on their bodies they'd been shot. He knew how many rounds had been fired. He knew about the box. He knew things that only he could know because he's guilty. And we talked, Mr. Schaefer said in his opening statement that some crimes aren't about the what, but they're about the why. And I expect he's going to get up and talk to you quite a bit about the why in this case. And I expect Mr. Jordan is going to have a lot to say about that as well once he gets a chance to talk to you. I'm here to talk to you about the what. And the what is proven beyond a reasonable doubt that this defendant committed a burglary on September 30th of 2018 at that Sonoma Court apartment here in Bexar County, Texas. In the course of that burglary, he intentionally murdered Nicholas Milanovich and he intentionally murdered Julia Wright by shooting them both in the face. That's what the evidence shows. This defendant is guilty of count 1, guilty of count 2, and guilty of count 3. Thank you.
May it please the court, defense counsel. Good afternoon. I'm going to address you first. I'm going to talk about the charge. George has given me the job of talking to you about the charge, and I look forward to talking to you about 52 pages of things that probably just put you to sleep, but that's my job. And so when I talk to you about the charge, while the state did talk to you about the charge at first, it's important to know there's a few things they left out, okay, and we're going to try to cover that. Now, there were 3 charges, and I understand his flow chart, and I've never been great with flow charts. But I understand there are 3 charges. And first charge, I think it's intentionally and knowingly causing the death of multiple people during the same transaction. And when we talk about intentional, I think it's something important to understand what does intentional mean. Intent, it's a definition that you're going to get on page 6. A person acts intentionally or with intent with respect to the result of his conduct when it's his conscious objective or desire to cause the result. Person acts intentionally or with intent with respect to the nature of his conduct when it is conscious, objective, or desires to engage in the conduct. So when we talk about count 1, it's about his intent in terms of did he intend to cause the death of Nicholas Milanovich? And did he also intend, that was his intent, to cause the death of Julia Wright, and they were both during the same criminal episode. So that's count 1. Count 2 is it was his intent to cause the death of Nicholas Milanovich while in the course of committing burglary. And then count 3 was what's his intent to cause the death of Julia Wright while in the course of committing burglary. So there's 3 different counts, 3 different capital murder charges. So when you look at the chart, what's the first thing you do? First thing you do is you have to ask yourself, does duress apply? Because that's something that he's apparently forgotten to talk about. What is duress? Well, George talked to you about it earlier. It's essentially, is there a threat of imminent death or serious bodily injury? And is it a threat such that a reasonable person of firmness would be incapable of resisting and you didn't put yourself in that situation? So really what it means is, was there a threat of some sort of imminent death or serious bodily injury? Did someone threaten Jilson? That's the first question. And this is the one part where we have the one burden that we have is to prove that by preponderance. Think of it as sort of 51%, sort of just getting over 50%. That's the one thing that we have to prove, if you believe that applies, is that in terms of duress, was there a threat? And so if you believe by preponderance that duress applies, then that's it. I mean, if you believe that applies to any of those offenses, then you don't have to do anything. You find them not guilty and you move on. So that's the first thing you have to do when you look at the charges. Does duress apply? Once you get past duress, you have to ask yourself the second question is, all right, if duress doesn't apply, did the state prove it to you beyond a reasonable doubt? That's not also something that they didn't really talk about very much. What is beyond a reasonable doubt? Well, I think George talked to you a little bit about during jury selection. You know what preponderance is? It means by just over 50%, 50.1%, that it's more likely true than not. That's a preponderance. And when you get beyond preponderance, what's the next standard? It's clear and convincing evidence. Evidence is clear and convincing. That's the standard that they use to take children away. And then the highest standard is, of course, beyond a reasonable doubt. That's their standard of proof. They must prove to you the facts beyond any reasonable doubt. And if you have a reasonable doubt of anything, then you find them not guilty. But that's something that they didn't really talk about because they don't really want to focus on that, because it really is the highest standard. It's the same standard that you use for a speeding ticket, for a DWI, or for capital murder. It's the same standard that you're going to use if you're going to convict someone and take their freedom away. It's the highest standard that we have in this country, and it's what they're required to prove to you. We're not required to prove anything to you. In fact, if we wanted to just sleep during the trial, we could have. Not that we would, but it's something that it's not required. We're not required to bring to you any evidence at all. They're required to bring you evidence. Even though when you look at the evidence that you heard, it really wasn't much other than a statement. Even the detective, one of the few things Detective Duke would admit to was, yeah, I realized I didn't really have any evidence beyond reasonable doubt until I talked to him. And so, because he knew. No DNA, no fingerprints. And so that was important to Duke, is that's why he had to talk to him. So, in terms back to the charge, you have 3 counts. And the first thing you ask is, does duress apply? And if it does, then he's not guilty and that's it. But if duress doesn't apply, then the state proved to you beyond a reasonable doubt all the elements that they have to prove. That it happened in Bexar County, that on a date, that his intent was to cause the death of someone, of more than one person, that's for count 1, or during the course of a burglary, his intent was to kill Nicholas or kill Julia, counts 2 and 3. Now, if you have a reasonable doubt thereof, or you didn't feel that they prove it to you beyond a reasonable doubt, you're allowed to consider what's called lesser included offenses. So other than capital murder, are there other offenses that you want to think about? And you're allowed to. Count 1, you're allowed to consider, other than capital murder, did he just commit murder of Julia or Nicholas? Was his intent to cause their death? Or was he just reckless in causing the death of Julia? So those are the lessers that you get to consider on count 1. And then on count 2, the capital murder of Milanovich during the burglary, you're allowed to consider the lesser of just just murder of Milanovich, or burglary, that he burglarized the apartment, habitation. And then on count 3, it's also capital murder, but there's also, if you have a reasonable doubt thereof or you're not sure, you're allowed to jump to the next and consider murder or burglary. You're allowed to consider other options. So it's important to understand, so as a juror, what you do is, first of all, does duress apply? And if you think that duress applies, then he's not guilty and that's it. And then second of all, did he prove to you beyond any reasonable doubt, the highest standard in our system, of the offense? And if he does, then you find him guilty and that's of capital murder and that's it. But if you want to consider other options, you're allowed to. The other lesser included offenses other than capital murder, such as murder or manslaughter or burglary. So that's why the charge is so large, is that you have to be able to consider these things and ask yourself, what applies? Does the defense apply? And in fact, the counts 1 and 2 is, does self-defense apply? And that's their burden. They have to prove beyond a reasonable doubt that it wasn't self-defense, that it wasn't a reasonable use of force. And these are all burdens that they have, that we don't have. So again, does duress apply, or self-defense, doesn't matter. And then then number 2, did he prove to you beyond a reasonable doubt that the offenses occurred? And 3, if not, do other lesser offenses apply? And so ultimately, while there is a lot there, that is really your job. Is you have 3 counts, and do the defenses apply? Did they prove it to you beyond a reasonable doubt? And more importantly, what did they prove to you beyond a reasonable doubt? And that's why there's all those verdict forms back there. Guilty, not guilty of different offenses. You get to look at it, you get to consider it, and as members of the jury, that's your job. You are the ultimate decider of the facts. Whatever the facts are, that's what you get to decide. Now, as I wrap up, I think Mr. Schaefer is going to address to you, George, and talk to you about more things. There are a few things I just want to say, and I hope George doesn't get mine. But there are just a few facts that I want to point out. Did it seem like I don't know, it just seems like a few things that were just kind of sloppy. That there are a few things by the police that just weren't done well. They could have tried to get DNA from the window pane, but they didn't. They had bullets from the autopsy that they could have sent to Ed Wallace, but they didn't. They had some junior medical examiner she was supervised by her boss, who was somewhere in the building, and it's not like it was a capital murder, except it was a capital murder. And so you have to ask yourself, did they really do what they were supposed to do? Because it's their job to do that. Mr. Schaefer is also going to talk to you, George, about Jilson's statement. I think it's important when you look at his statement and you have to understand sort of the context of it. Ultimately, you're looking at a 20-year-old back then from Honduras who doesn't speak English against Detective Mark Duke, a very smart, very, very, very experienced detective. And Detective Duke admitted on the stand he didn't have a lot of it. In fact, he didn't have much. But he knew it was important to get Jilson to talk. So what does he do? He calls his friend at ICE and says, hey, it would really help me if you got picked up. And so that's what they did. They picked him up. And for a year, for 12 months, they let him marinate in some prison facility for ICE without bond, without anything, just letting him just stew there. And then that's when they decided to show up and go talk to him. And when they went to go talk to him, what was the first thing they said? What did Joe Ibarra said? Hey, you remember me? Remember, I'm the guy that arrested you. He wanted to let him know right off the bat, hey, I'm that guy that arrested you. And when they started talking to Jilson and they weren't able to get what they wanted, what did they do? They sort of switched gears. They started threatening him. That, hey, you're looking at the death penalty. You're looking at all these things. And so then he just started saying things. And George is going to talk to you about that. But it's just you have to understand when you're a 20-year-old and you don't speak English and you're from Honduras, and all of a sudden this cop is not just talking to you, interrogating you, he's lying to you. He's making up facts. He's saying, look, I have this information and I'm going to prove it. I'm going to prove it and you're going to be found guilty. Now I think he's very artful in his words, Detective Duke, in terms of, that they're going to prove it. And I understand what he meant, and that is, look, I'm going to get the evidence and prove it to you without a reasonable doubt. But what does Jilson think? A guy from Honduras. What does he think when someone says, hey, we're going to prove it. You're going to be convicted. Maybe he thinks, you know what? They're going to convict you if the evidence exists, or maybe they'll just create the evidence. I mean, Honduras is not it's not the United States, but that's beside the point. It's just important to understand he's 20 years old. He's not college educated like Mark Duke. And honestly, he never stood a chance against Mark Duke, because Mark Duke is very good at his job. He's getting very good at getting people to say what he wants them to say. But as I said, George is going to address you on that. But in terms of your job, it's simple. You go back there, you find a foreman, you decide whether or not the defenses apply. Did they state prove to you beyond a reasonable doubt the offenses? And in the end, what do you believe that he's guilty of? What do you believe that his intent was? And then when you look at the evidence and think about it, we hope that you make a proper decision. Thank you.
May it please the court. Thank you, counsel for the prosecution. I have practiced law for a long time. I've never seen as difficult a charge as the one that y'all are going to take back there with you, okay? It is what it is. Now, before I get started, first thing I want to do is I want to thank you all for being here. I want to thank you for the attention that you've given both sides during this trial. I know it was difficult watching the video. It took a long time. It was after lunch, but I saw you all paying attention. Now, I've made notes for every time I've argued. I've taken notes, but I really want to get to the bottom line here. Y'all have your notepads. Y'all know what was said. And while you're listening to the evidence, that's all you're doing is ingesting that evidence. We're sitting at table, and I might be writing an answer to one thing, writing another question I want to ask with respect to that. My bottom line is this. If I say something that is different than what you remember, use your own memory, okay? It's not an attempt to, inveigle you or fool you. Use your own memory. Now, the thing that we talked about during jury selection, why do you think that at the time we were picking you, we talked about lesser included offenses? We talked about maybe this is not what it should be. And if you recall, during my opening statement, I got up and I sort of harped about why the state says why is not important. We don't have to prove why. Well, that's true. Legally, they don't have to prove why. But factually, I think they should have. Because factually, I think they needed to. Because factually, that's what this case is about. You've heard the facts, you have the charge, and you have to sort of tell us why did this happen. Now, Nicholas Milanovich, Julia Wright, young kid, living together. He wanted to be someone who designed prosthetics. Was he in school at the time? His uncle was here. I can't tell you that. Did the state produce any evidence whether he was in school or not? I can't tell you that. Did they produce any evidence that he was working for a living to help pay for that apartment? I can't tell you that. There were only 3, maybe 4, if you consider Joe Ibarra. He's sort of a witness here, but he's not a key witness here. We have Melissa, we have Valerie, and we have Detective Duke. I'm not concerned about what the CSI said, who took pictures, who did this result, who did the autopsy. Those are the facts. You all have heard them. You'll listen to them. You'll see them. I do want to remind you that all of the evidence that has been admitted in this court, all you got to do is say to the judge, we want it, and it goes back to the jury room with you, okay? So you'll have the photographs. You'll have the tapes. You will have the other exhibits that are here. The state has the burden in a criminal case, okay? And if you remember during jury selection, I said, if you ever got a traffic ticket and you just paid it even though you shouldn't have, why you should fight it. Why you should have people decide, am I guilty of that? I mention that because I think my client certainly has, based on the evidence, responsibility here. Okay? You didn't hear him take the stand and say it wasn't me, it was someone who looked like me, or it was my twin brother, or it was any other unimaginable deal. I think he's got some responsibility here. But I think he's not the real culprit. Okay? Take everything else aside and look at his declaration to the police. Been in custody for a year, as counsel has stated. He has an attorney actually representing him on his ICE stuff. Did the detective ask about it? No. Well, detective, had you known that he had counsel, would you have even consulted her? No. I'm curious about that. You should be too. I think the real culprit here, if you believe what the defendant said in his statement, is Melissa. And I want to emphasize something about Melissa. Why did she contact her attorney? Why did she keep all the clothes that were supposedly worn during this transaction? Why did she take them to her lawyer and say, I need for you to get in touch with the cops, but don't tell them who I am? Why? Because I think she's one of the culprits that should be sitting here also. Now, the why. Defendant, poorly educated, from a foreign country, who does not understand our system, who does not necessarily understand our law and how we process matters before juries. What's he doing? He's working, He's living with the girlfriend. As he said in the statement, he's trying to live a better life, to get a better life. There were some facts in here that surprised me, by the way. A couple of facts. I asked Valerie, last time you talked to the defendant, last week when I talked on the phone. That came as a surprise to me. But then, when Melissa says the same thing, that comes as a surprise to me. Now, understand that while they're talking on the phone, their phone calls are recorded. State hasn't brought anything here to show that there was any undue, say this, don't say that, blah, blah, blah. Because if there was, they'd have brought it. If there was any indication of problem, they would have it. Why do I mention that? Let's get back to what the state's duty here is, to seek that justice be done. Not necessarily to convict, but to seek that justice be done. Now, the evidence. Detective Duke, in interviewing the defendant, Mr. Milanovich is a real bad guy. He's committed robberies. He's hurt a lot of people. And you notice that I interrupted the state and I asked Judge, may I take him on voir dire and ask him one question? And I said, is that a lie? And his answer was unequivocal. And we understand that the police can do that. We asked him about the amount of drugs. While I'm talking, I'm going to be looking for something, okay? And I asked him about, did you see any drugs in the house? Oh, well, there was some marijuana. And we asked him about what else. Well, there was a grinder. Asked him about the pipes, and it's funny because when the state asked him about the pipe, he said, oh yeah, there was a pipe. A pipe. A pipe. And then when I had him on cross, I said, well, no, wait a minute. There's more than this bag of marijuana, wasn't there? Well, yeah, there was also some on the patio upstairs. Okay. And then when I asked him about what else was it, or where else was it, he said, oh, yeah, there was also some on the coffee table. You know, to seek justice is an important concept in our society. But getting back to Melissa, getting back to the real culprit here. Selling drugs, who knows? I can't tell you that Milanovich and Julia Wright sold drugs, had heroin, had methadone, had ice. All I can tell you is that the evidence discloses that there was lots of people coming and going. Melissa says, well, they were competing with my business. And this is where Melissa rubs me the wrong way. Because didn't she give her stuff, his clothes, to her attorney to contact the police, keep me out of it, but to protect herself? If he goes down, they ignore me. at the time the defendant gives his statement, he hasn't spoken with an attorney, he hasn't solidified a defense. He goes from, I'm basically a nice guy trying to earn a living to getting ground down a little bit by Detective Duke, by Agent Ibarra. And it's funny, the levers that they used. Are you a Catholic person? What would your mother say? And I want to tell Milanovich's and the Wrights, their families, about what happened. I want to be able to explain to them. This all gets back to the why. And I want to explain to you that if you come forward, if you acknowledge what you did, it's the jury's hands, and he's right about that. It is in your hands. Well, jury's sure going to feel better if you acknowledge what you did, which this defendant did. I did it. I'm sorry I did it. He did it. He confessed to it, and he told you in his statement that he did it, and he had some facts that only he would know about, only 2 shots. What a horrible loss for the Milanoviches and for the Wrights. What a horrible loss. Young kids killed at the beginning of their adulthood. I wish none of us had to be here today. I wish I didn't have to be here talking to you. I wish you didn't have to be here, but you do. You have your job, and I have mine. The state has very, very effective prosecutors, okay? The state has people that are good at their job. And I want to compliment these 2 guys because they did a professional job. I'm not going to wait till later out of your presence. They did a good job, and I want to acknowledge it. Y'all come here separately. I'm sure none of y'all rode here together, okay? And when this case is over, you're going to go home again separately. And you may never know what happened in this case beyond reading it in the newspaper after it's all said and done with. But I want to urge you, you have to make up your own minds, okay? You have to make your own decision. And I'm saying this because there are lesser included offenses. You have the offense of capital murder, that's one of your choices. You have the offense of murder, and that's a second choice. And you have manslaughter, that's a third choice. And you have burglary, and that's a fourth choice. You have to read the charge, and you have to decide. But I want each of you to make up your own mind. And if you believe one thing, and that's what in your heart compels you to act, and it's different than 11 other jurors, okay? If you believe one thing, stick to it. And if you're looking at 11 jurors that disagree with you, if you're right, you're right. And that's what deliberation is about, for y'all to talk and for y'all to decide maybe you should change your mind. But if you're right, stick to your own decision, okay? I can talk about the facts for a long time, okay? But I'm not going to change anything. I'm going to quote Detective Duke, I'm not going to unscramble the eggs here. You've heard the facts. And I think the two things that I've talked about consistently are the facts, take them, listen to them, do what's appropriate. Don't forget the why. Don't forget why we're missing two people in our society who should be here with us. Don't forget the defenses that are available here. Duress, self-defense. Don't forget that this person who has nothing to know about anything says, I went in there. Why? Probably to steal the box, probably to find their dope or their money or whatever. And he goes upstairs and Nicholas points a gun at him. And we know there's a gun because the state put on evidence of the Walther that was in his car, the Walther PPK. And we know that there's a gun because his bullets are right there by the bed. They searched the house. Find the gun? No. Probably because the gun was taken. Just like the defendant said in his statement. I walked in, the gun was sitting on top of the lockbox. He pointed it at me, and I responded. I have a lot more time, and the court will probably shut me off if I get close to it. There's not a whole lot more I can say here, folks. You've heard the facts. Think about the why. You've heard the facts. Think about the lesser includeds. Think about what Detective Duke told him back in December of 2019. Maybe a 30-year sentence would be better than your life or death. Think about those things. Again, I thank you for your attendance. I thank you for your patience. I thank you for your verdict, whatever it's going to be. I've done what I need to do here. Time for y'all to do what you need to do here. Thank you.
Yes, Your Honor. May it please the court, opposing counsel. Guilty, guilty, guilty. Good afternoon, ladies and gentlemen. At the beginning of this trial, I told you that at the end of the trial, we would ask you to return the only true verdict as it applies to this case, based on all the facts and all the evidence. Well, here we are, ladies and gentlemen, as promised, at the end of this trial, and that is exactly what the state of Texas is asking you to do. Guilty as to count 1, capital murder. Guilty as to count 2, capital murder. And guilty as to count 3, capital murder. All of the facts and evidence in this case has proven that beyond a reasonable doubt. There should be no reasonable doubt in your mind as to all of the elements that the state had to prove after those 3 counts. And honestly, ladies and gentlemen, this case was never going to be about who done it, right? Who did this crime? How was it committed? When and where? It honestly wasn't. Because I told you that all the facts in this case would prove it. And not only that, but the confession of the defendant. The confession of the defendant, his own words, would prove it to you. What this case was always about was whether or not the defenses that he raises during the course of that interrogation were true or not, right? Whether they apply to this case or not. And those were the defense of self-defense, where he briefly mentions in that interview, oh, and I saw him reaching for a gun, which is nonsensical, but we'll talk about that. And the second one, duress. We addressed it even all the way back to jury selection. It was very important that we did so because we suspected that that was going to be the defense, right? So what I want to talk to you now, while I have you here, and then when I'm before you, before I sit down and you're asked to deliberate, is why they don't apply to this case, right? Self-defense, if you remember back in jury selection, there was a juror that was sitting way in the back left. I think it was 66 if memory serves. And he said, Mr. Jordan, what about if someone breaks into your house in the middle of the night? Would I have self-defense in that scenario? And I believe that everybody on the panel was pretty much on board that yes, juror number 66, you would, right? That's exactly what happened in this case. Who had the right to self-defense in this case, ladies and gentlemen? Who? Milanovich. That's it. No one else. It's his house, his habitation. There's an armed intruder inside of it, in the middle of the night. Are we really going to say, oh, he had self-defense to shoot Milanovich?
Judge, I'm going to object because the court has given the instruction in the court's charge, and that argues with what is in the court's charge.
And ladies and gentlemen, you're going to be able to take the charge with you back there. It's all in there. I know it seems really convoluted and very difficult, but it really isn't. It really isn't. And the reason why it's not is because he's guilty of count 1, 2, and 3. You don't have to delve into all of those other things. It's guilty, guilty, guilty. It's the second paragraph under each one of the counts. Count 1, count 2, count 3. It'll be that second paragraph that says, we, the jury, find the defendant guilty of capital murder. Simple. Self-defense does not apply. Let's talk about duress. Let's talk about duress. I had a slide, but it doesn't matter. I hope you remember the example. We talked about duress by using the example of a stool during jury selection, if you remember. And that stool had 3 legs. The 3 legs that have to be present in order for a defendant, this defendant, to climb on top of that stool, to stand his ground on that stool and say, duress, if you remember. If any one of those legs is missing, the defense of duress fails. What were those 3 legs? Any one of them missing. Those 3 legs were, number 1, it has to be a threat, an immediate threat of serious bodily injury or death. That's leg 1. Leg 2, right, is a reasonable person would not be able to resist the threat and would do the act. And number 3, the person wouldn't be able to intentionally, knowingly, or recklessly place themselves in the situation to be affected by that duress. Okay? So, what this defendant wants you to believe is that that woman that took the stand, Melissa Cortez, the drug kingpin, right? The woman super wanted by law enforcement, yet somehow was working at a laundromat when she met with him for the first time, and is now living with her grandmother and working at a nursing home. And in the last 15 years has only ever had 2 felony convictions, one for THC, a vape pen, and then 15 years ago for possession, not even with intent to sell, of narcotics. That this woman has all these cartel connections, and she's connected to the Mexican mafia and to the Tango Orejones and to the cartels in Mexico. And that she has killers on speed dial. Right? During the course of his confession, he even describes an event for Detective Duke where a man that owed Melissa money was drugged in front of her store and shot in the legs. So a woman that has literal cartel hitmen that can evade detection after shooting someone in the legs in broad daylight in front of a store needs to recruit Jilson Avelar-Rodriguez to go and effectuate 2 murders on these 2 young individuals, on Mr. Milanovich and on Ms. Wright. How does that make any sense? It really doesn't, right? It really doesn't. There was no duress in this case. Well, let's talk about it, right? The immediate requirement. Immediate threat of serious bodily injury or death. At what point during the course of that confession does he specifically say what Melissa was going to do to him or her people? He just keeps saying this vague, do something to me. They were going to do something to me. What does that mean? Right? Do something to me. The immediate requirement. At one point during that interview, and all the lies and tales that he was spinning, he says, and at one point she gave me 3 days You remember hearing that? 3 days, and you're going to have the transcript right before you, 112, as well as the interview video. In what world is you have to kill these people in 3 days immediate? At that point, you can resist. Go to the police. Tell Valerie about it, right? Like, hey, this is happening, what do I do? Right? You don't have to do that, assuming true, which is absolutely not true. Further, she allegedly shows up at his apartment on the day of the murder, on the night of the murder, and she says, you have to do it now. At any point during that confession, does he say, she was armed, she pointed a gun at me, she held me at gunpoint all the way to that window where she told me to enter, and if I didn't do it then, she would shoot me. Where's the immediacy? Right? You're at home. Someone's knocking on your door. You check. You see it's Melissa. You don't open the door. Right? Further, he goes inside, having now, according to him, been armed by Melissa. So now he's standing inside of the victim's apartment, holding a 9mm firearm, and he says that Melissa leaves and goes either to her store or back home. So now you're alone, in the apartment, armed. How is this immediate? How is there any threat at that moment? You literally have a firearm in your hand that you can use to defend yourself. It makes no sense, ladies and gentlemen, because it's a fabrication. And that should be apparent through the course of that interview. The entire time he was just trying to either distance himself from the crime, as he was doing initially, and then trying to mitigate his culpability. Remember that? Remember that second story that he told about, oh, I just opened the window, until he was confronted with further facts, right? We know we were inside, which may or may not have been true, but that doesn't matter, right? And then he's like, okay, fine, I was inside and I did shoot, but it was under coercion. It's obvious that he was just trying to mitigate and distance himself from culpability the entire time. The entire time. Duress does not apply in this case. The facts are what they are, ladies and gentlemen. There should be no question in your mind that this man murdered those people, assassinated them in the middle of the night by shooting them in the head as they slept in their beds, and had zero chance, zero, to defend themselves. None. The defense talked about Melissa coming forward and presenting that information to the detectives. And thank God that she did, honestly. Thank God that she did. Because I'm going to put this thought in your mind. It's something that's bothered me, and I know that it may bother you. If she hadn't done that, it is very likely, quite possible, that we would not be here today. And that a man that snuck into another person's apartment, 2 people, in the middle of the night and killed them in cold blood would walk. And that thought just boggles my mind. It really does. Because like Mr. Schaefer said, and I do agree with this, I too, and I'm sure Willem agrees with me, and every prosecutor in this office I'm sure agrees with me, I too wish that I didn't have to be here today. I too, in my seeking of justice, wish that justice prevailed every day, and that righteousness prevailed every day, and that murders like this wouldn't happen, but they do, and that's the real world. So I'm going to leave you with this final thought, ladies and gentlemen, and it's this. At the end of the day, those streets out there are your streets, and this county is your county. So, if this is the kind of behavior that you don't want to see happening in Bexar County, find this defendant guilty, as all the evidence, all the testimony proves beyond a reasonable doubt. And I assure you that when you come back with that verdict of guilty as to count 1, count 2, and count 3, you will not be telling this defendant anything that he doesn't already know. Because he knows what he did. He does. I also want to thank you for your time and consideration in this matter, and I pray, and I know that you will reach the just verdict in this case as you help us seek justice in this case. Thank you.
Thank you both for your excellent presentations. Ladies and gentlemen of the jury, you have the evidence, you have the court's charge, and you have heard the closing arguments. I have given the bailiff the court's charge and the verdict forms. They will also provide you with any of the exhibits that were admitted. I am going to caution you if you're going To intend to handle any of the evidence, you need to wear some gloves. Once you are all assembled in the room, the case is formally submitted to you. The first thing you should do is select a presiding juror. So what that means is you can finally talk about this case. You need to deliberate about this case. Please follow the bailiff to the jury deliberation room.
All right, for the jury, please bring your writing materials with you.
Thank you. You may be seated. Who's the fourth person? What's your juror number?
11 now.
Mr. Foreperson, does the jury have a verdict in this case?
Yes, we do, Your Honor.
And is your verdict unanimous?
Yes, it is.
Can you hand everything to my bailiff, please? I will inspect the verdict to make sure it's in proper order. Defendant could please rise. One. On count one, we, the jury, find the defendant Jilson Avelar-Rodriguez, aka Andres Rodriguez, guilty of the offense of capital murder as alleged in count one of the indictment and as instructed in paragraph 7. As to count one, does either side wish to pull the jurors?
No, the state judge.
Yes, Your Honor.
As to count one, what I'm going to do is start in the back row. Where are my alternates? Okay, so not you all, everyone else. I'm going to start in the back row, and I'm just going to point at you, and you tell me if this is your verdict. Is this your verdict?
Yes.
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 The front?
Yes.
Yes.
Okay, let's move on to count two. In count two, we, the jury, find the defendant Jilson Avelar-Rodriguez, aka Andres Rodriguez, guilty of the offense of capital murder as alleged in count two of the indictment and as instructed in paragraph 10. Does either side wish to pull the jury as to count two?
No, the state judge.
Not at this time, Your Honor.
Count three. We, the jury, find the defendant Jilson Avelar-Rodriguez, aka Andres Rodriguez, guilty of the offense of capital murder as alleged in count 3 of the indictment and as instructed in paragraph 13. Does either side wish to pull the jury?
No, the state, Your Honor.
No, Your Honor.
Ladies and gentlemen of the jury, I will accept your verdicts as you have delivered them to us today. And I want to thank you on behalf of everyone for your service in this case, including the alternates. Thank you all for being here every single day with us. We started off last Friday. We stayed late into the evening to pick a jury that could be fair and impartial. And you all took the oath to deliver a verdict based on the law and the facts in this case. And we thank you for your service. We can't do our jobs without you. So at this time, your job and your duties are finished. You've concluded your service. You are released from all the instructions I have given you previously. And I will meet you at the conference room as soon as I'm done in here. Okay? With that, one last time, I'll rise for the jurors. I need the TV moved out of it. We can move it. We don't need it anymore. You may be seated. State and defense, since the verdicts in this case all came back guilty on capital murder, I am required under the law to vacate.
2 and 3.
Is that your request to vacate 2 and 3?
Yes, Your Honor, he can only be found guilty one time of the offense.
Correct. So we don't violate double jeopardy. I have to set aside counts. So do you want me to set aside count 1 or count 2 and 3?
I would prefer that you set aside count 2 and 3, but
Yes, Judge, 2 and 3.
At this time, notwithstanding the jury verdict, I am setting aside the verdicts in count 2 and 3, as it is a violation of double jeopardy. Are we ready to proceed to sentencing?
Yes, Judge.
yes, Your Honor.
Mr. Jilson Avelar-Rodriguez, can you please stand? Mr. Avelar-Rodriguez, you have been convicted of the offense of capital murder as alleged in count 1 of the indictment. At this time, I am going to sentence you to the Texas Department of Criminal Justice Institutional Division for a period of life confinement without parole pursuant to Chapter 1231 regarding capital felonies. You are remanded to the custody of the sheriff to begin your sentence. I find that there is an affirmative finding that a deadly weapon was used in the commission of the crime, and there is to be no contact with the family of Nicholas Milanovich and the family of Julia Wright.
Judge, with respect to the sentence, and I know this makes no difference whatsoever, we would ask him to get credit for all the time he served in ICE confinement. Again, I know it doesn't make any difference, but he was there as the basis of this prosecution.
I am not going to give him credit for the time that he was picked up by ICE in 2018 because there was no state warrant holding him. I will give him credit from the time that the warrant was executed on the capital
He was
murder.
placed into Bear County.
From that day going forward, he gets credit for all of that time.
Thank you, Your Honor.
At this time, do we have victim impact?
I believe we do, Your Honor.
Let's get started.
Okay. The phone call we received on Sunday, September 30th, 2018, about the murders of our son, Trey, as we call him, and his sweet Julia, has forever changed our lives. Your senseless murder of them has never made any sense. They were gentle, loving, and kind-hearted, and didn't deserve this. Our faith in our Lord has sustained us and has been our strength to help us continue to move forward one day at a time. We want to thank everyone who helped ensure that no other family will ever lose a loved one by your hand and experience the pain and loss we feel on a daily basis.
He's remanded to the custody of the sheriff and when that room is closed.
This time, I'll do it later.
Do you need to do it on the record?
I'll do it later, Judge.
I'll get the okay for the jurors for you guys to go back there and talk about it.
Yes, Judge. Thank you, Your Honor.
Do we have work excuses?